Hi, my name is Akiva Goldman. I'm the director and founder of Goldman & Associates. Our firm has a primary focus on family law issues here in Michigan, and today we continue in our video series designed to educate the public, so please subscribe to our channel. Today we're going to talk about the increase in alimony. You know, if you want an increase in alimony, in most judgments, the court is going to say alimony is going to be X amount of dollars, or until further order of the court, that's what the payment is. Now, the court often leaves that open so that a person can come back and say, look, the circumstances have changed. Because of that compelling change in circumstances, I want more alimony. I want an adjustment upward in the amount of money that I'm getting. Can I get it? Well, in situations like that, the court will conduct a hearing to determine what the degree is of the change. Are they in fact changing circumstances? Is it sufficient to warrant a revisiting of the alimony? And if so, should there be an increase in alimony, what will it be? And then the court would enter appropriate order. What do you do if it's been denied? Your motion has been denied. Well, thing number one, you have to understand why it's been denied. If it was denied for some procedural reason, like somebody wasn't appropriately served, the notice hearing wasn't set up properly, or some such thing like that, that's something that can probably be cured and won't necessarily go to the merits of whether or not you're entitled to the increase. Therefore, it's important to consult with an attorney or your attorney to find out, I was denied, but why was I denied? Was I denied in a way where it makes sense to refile, or does something else have to happen? So, for example, in a case where everybody's been served, everybody's been noticed up, the court has conducted a hearing, everybody weighed in on it, and the court made a reasoned ruling based on, for example, the alimony factors, based on the need, based on other things, and the court, having come to a conclusion that you're not entitled to issue an order denying your request, then the question is, well, gee, can I go in and request a reconsideration or even an appeal? Well, you have to understand, when you move for reconsideration, you can only bring up some new factors that weren't known at the time. So in other words, a motion for reconsideration is going to be very limited. Not only that, in most cases, you're not going to get an oral argument on your motion for reconsideration. So it's just going to be a filing, a motion for reconsideration, and then the court issues its written opinion. The question then becomes, should you go to the Court of Appeals and take appeal from the ruling on the basis that the court committed an error in law, didn't consider what it was supposed to consider in your motion to increase, or the other way around, considered factors that it should not have, as a matter of law, gotten into. You can argue that, but your attorney will tell you that the likelihood that the Court of Appeals will reverse the lower court decision and remand for further proceedings, that the odds of that are something to consider. Sometimes the odds are quite small, so you have to consult with your lawyer on whether or not it makes financial sense to allocate the time and considerable resources that are involved in filing that appeal. Now, if you have any questions about that, reach out, and of course, we'll be glad to help you out.